Good morning. Welcome to this event organised by the Oxford Global Society. My name is Denis Galligan, Professor Emeritus of Oxford University and Director of the Oxford Global Society. I'm very pleased to welcome our two discussants today. On my left is the author of the book, Frank Vibert. Let me just say a little word about Frank. Frank is a former senior advisor to the World Bank. He then returned to the United Kingdom and founded the European Policy Forum, an important think tank. He then entered academic life and has been associated with CARR at the London School of Economics for many years. Frank is the author of a number of books. I'll just mention two of them. One that I think caught the attention very much of a lot of people was The Rise of the Unelected in 2019. Then in 2021, his book on comity, multilateralism in the New World Order, in the New Cold World, New World Order, let's leave it at that. And now Frank has written the book, which is the subject of our discussion today, Rethinking the Separation of Powers, Democratic Resilience in Troubled Times. I think when Frank published this book, a year or so ago, times were less troubled. So it seems an enormously pertinent book to be considering at this time in world events. On my right is Sir Jack Beatson. Jack is a former academic here in Oxford and then Cambridge. He was appointed to the Law Commission, and after serving the Law Commission for several years, he went to Cambridge, to a chair in Cambridge. In 2003, he was appointed a High Court judge, and then in 2013, he was appointed to the Court of Appeal. He now retired and fortunately has returned to his real alma mater, that is Oxford, and so we have the benefit of his advice and his comments. So the basic idea today is to discuss Frank's book. So I'll ask Frank to introduce it very briefly, the main themes. Then I will ask Sir Jack to reply, and not so much reply, but to develop, identify the themes that he would like us to discuss. And then we will emphasize the discussion part. I also have a few issues I'd like to put to Frank. Anyhow, without further ado, Frank, over to you.
All right, thank you, Denis, for that introduction. The separation of powers is taken to mean separation between the legislative branch of government, the executive, the judiciary, and to that I've added in the discussion in the book what is usually seen as a new branch of government, independent agencies which have expert knowledge in a particular sector like health or education or sector regulation as an additional branch of government. I wanted to, in this book, to look at three main questions. Is the separation of powers still relevant as a form of government? After all, it's quite an old idea. What should we compare it with? And by what standards should we judge it? On the comparators, I looked particularly at a power-sharing model of consociationalism, which we associate with Belgium, Netherlands, Switzerland, for example, and very much with the writings of Arend Leipart. I also compare it with what I call rights-based government, which I take the EU as an illustration, where statements of rights bring all institutions together under a common canopy. In terms of what standards one should judge different systems of government by, I look particularly at resilience, their ability to withstand shocks and to deal with unknowns. And of course, it's very much under test at the moment. What are the lessons from the book? What are the main messages I want to get across? First of all, I think the importance of viewing systems of government as learning systems, and that means protecting their different sources of authority, the judicial source, the electoral source, and the expert sources of knowledge. It also means, according to me, paying much more attention than is done to differences in income and wealth. Montesquieu and the founding fathers of the American system is often forgotten, did say that if the wealthy get their way, they'll upturn the system of government, the representative system of government. And that warning, to me, remains valid. And one's only got to look at the OECD statistics on income and wealth, quite apart from looking at Musk under Trump, to realize that this is an important warning. And the third message I want to get across is the importance of what John Stuart Mill referred to as vitality, which means that citizens have to be ready to defend their system. The American founding fathers took that for granted. John Stuart Mill defined it in terms of being ready to do debate with those we don't agree with, and in terms of being ready to share the benefits of our own experience in experimentative living. That was his phrase. And I think that the importance of people being ready to stand behind their democratic system of government remains extraordinarily important and is the ultimate defense of the system. And I think, Denis, you've expressed pretty much the same view in your idea of people as the keepers of the system. They are the ultimate safeguard of the system. Well, I think those are the main points, Denis. So have I kept within the time?
Thank you. Yes, very good, Frank. You've set a good precedent. Yeah. Would you like to start the debate by raising your comments?
Yeah. I'm going to focus on the encouragement of learning perspective, which Frank's book sees as the main test of the best democratic architecture. And he does this against a background of democracies being unexpectedly fragile. I come at this from the point of view of a lawyer. I know Frank notes that independent judiciaries are under attack from those claiming greater democratic legitimacy. And I observe that a similar critique could be made of indirectly representative bodies, such as legislatures, and also of independent expert regulatory institutions. The critique is from those who claim that the indirectly representative bodies don't in fact reflect the views of the people they are supposed to represent. And the expert regulatory institutions assume that there's a clean line to be drawn between what they, with their shared norms within one institution, consider to be scientifically established facts and contestable opinions. Frank says that elected bodies need what knowledge and information experts have to offer, and expert institutions need to be observant. Perhaps it's slightly less than that, perhaps it's only sensitive to the values promoted by elected bodies. Denis Galligan considers that one should be emphasizing the perspective of the people. I'm not going to say anything because he'll say everything that needs to be said about that. On the book, there's much in the approach with which one can just agree with. But I would want to give less emphasis to the concept of separation, because I don't think we've got it in the UK. I'd prefer to think of an approach which identifies the balance of powers and thus the balance of responsibilities between the different components of the state, which a man who had been Solicitor General in this country and later became a very distinguished judge, Lord Simon, thought was a more subtle and nuanced way of discussing things. And I also feel that expert regulatory institutions are in a sense inferior to the other classical components of the separation of powers, because they are a creation of them and can be abolished by them. There are theoretical debates about whether one could abolish independent judges and all that, but the regulatory institutions are a creation of them, and they can be abolished by them. In this country, we've just seen one of the independent agencies responsible for health abolished and the functions reabsorbed into the Department of Health. So although one has to recognize that while they exist, they may be given extraordinarily wide powers. You can see those in the Legislative and Regulatory Reform Act in 2006 in the United Kingdom, and the Constitutional Reform and Governance Act 2010. I'm not sure what, given this, the structural way is of bringing together the judgments from politics voters with the empirical evidence of experts, other than by having people who are in favor of cooperation. It may be a cultural thing rather than anything more than that. I think that 3 examples show a real great advantage of the separation of powers reformulated in the British way as the balance of responsibilities to a learning perspective. The first thing is the way that the common law, and this and other countries that have it, has a way of developing the law, providing certainties by identifying principles with sufficient certainty to provide guidance as to what's required, while leaving room for further incremental development, or if there is incremental development and a problem is identified, taking a rather crab-like step backwards or sideways, as has happened in many particular cases. Secondly, I think that the way that the legislature in this country, in the Human Rights Act, did not authorize courts to strike down public conduct which is incompatible with fundamental rights, but left the legislature in the driving seat. They could make a declaration of incompatibility, and the baton is then passed back to the legislature as to how to address that incompatibility. I think that is a way of encouraging learning. It sometimes encourages fights, it has to be said, but it's a way. And the third thing is, more relevant to the expert bodies, is the circumspection, but also to government, the circumspection generally showed by courts in relation to sensitive and deeply controversial social and ethical issues, assessments concerning scientific and technical questions, allocation of limited resources, and predictive decisions on questions involving national security, terrorism, public disorder. Colorful example from my own experience, I had to decide on whether a regulation that made an assumption about why salmon were disappearing from parts of the Bristol Channel was scientifically based or not. And there was a challenge to it by salmon fishermen who thought that their livelihoods were going to be corrupted. And the way the courts dealt with it, both the first instance court and in the Court of Appeal where I saw it, was to give great value to the scientific evaluation of the Environmental Science Organization and the work, and Exeter University and others. And I think that's a way of not leaving them completely free, but again, passing the buck back to them, and if they step outside that. But the fact that all the courts do is subject to the sovereignty of Parliament means there's little that they can do to address the feelings of some that they are unrepresented or underrepresented, or the challenge of organizational resilience. Because Parliament can do anything. And what happened to the health regulatory body recently is an example. Although the two Miller cases on the way the UK navigated its withdrawal from the EU shows that sometimes there can be a contribution to organizational resilience. But ultimately, it's give and take. And those are my comments on the book, which is an excellent book.
Thank you. Frank, would you like to reply to those or comment on those comments?
If you'd like me to do that before you come in with
I'd like to hear your view on comments.
Yes, I think you're right that the judiciary and expert bodies are both under attack, I certainly agree with that. You suggest less emphasis on the separation of power and more emphasis on the balance of powers, which you see as the great advantage of the British system. I would be more enthusiastic about the British system if I didn't see it as incurably elitist, and the revolving door between the House of Commons, regulatory bodies, the House of Lords, the judiciary. And I think who's only got to look at a series of bad public decisions, whether it's High Speed 2, post office scandals, the mishandling of Brexit, to see that the elitist system we have does not serve us well. And my first step to change it would be get rid of the House of Lords.
That's another subject.
That's another subject.
It's another book.
So I'm certainly not a fan of this so-called balance of powers, which is really just serving the elites. Your point about expert bodies, that they're inferior because they can be abolished. Well, they can be abolished, but you still need that expert knowledge somewhere. And John Stuart Mill argued in the middle of the 19th century that it's better it is outside government because it's easier to judge that it really is expert and not just contaminated by political views. And I still think that is right. And I don't think courts, even though if they give respect to expert bodies, they're not the right bodies for mobilizing, say, scientific knowledge. They've got their own expertise in judicial knowledge, not in the knowledge of science or economics. And I don't think it's reasonable to expect them, except in very rare circumstances, to have that kind of expert knowledge. So I agree with your point about incrementalism and the advantages of the common law. But that also applies to politics. And I would suggest that incrementalism in legislation is also an advantage, and that's very much associated with the gradualism of Lindblom. But that is not incompatible with the separation of powers, except insofar there is a weakness in separation of powers, and it's what is known as punctuated equilibrium. That the system of government tends to go in lurches. You need control of both houses, otherwise there's a stalemate. So in that sense, it's not very conducive to the kind of gradualism you and I both think would be an advantage, and it's just a weakness of the American system, but it's not as severe a weakness as the kind of immobilism, inability to take decisions you get with consociationalism. So I think we agreement on certain points like gradualism, but I'm afraid I have no truck with the British system of elitism, which you glorify as a balance of powers.
Well, thank you, Frank. We seem to have a very healthy division of opinion here, but I want to add another ingredient in this debate over expert agencies and so on. What about the people? What about those who have an interest in the issue, whatever it be? I think if we study the systems of administrative law, that is, the law and process relating to the operation of government agencies, the controls to which they are subject. In other words, a huge development, in a sense, under the constitutional structure. This is the interesting point. That administrative law gets hidden away as if it were a sort of technical implementation of legislation. This is far from reality. if we look at the United States system of administrative law, the British system, the continental systems, we find very highly developed approaches. And amongst those approaches basically to control, to have influence on, and to ensure certain standards are met by any administrative body. Or to put it another way, each of those many administrative bodies, from the highest executive levels down to very local authority matters, each of them has a certain amount of power. Each of them has a certain, what I would call a discretionary space in the exercise of that power. And the people, those with an interest, and what that means is a big issue, but those who have some way their interests are affected, generally speaking, have a right to be engaged in the process. And I think that dimension, first of all, is missing from most discussions of constitutional systems. Secondly, I think it is very relevant to this discussion of the seemingly detachment of agencies exercising special knowledge or scientific knowledge. Even those agencies have to account, have to justify, defend their actions. There are proceedings, there are aspects of due process which enable citizens, interested parties, to engage in those matters. And although this is a huge subject, I think it is a dimension that needs to be added in, Frank, to your analysis, valuable as your analysis is. And of course, your earlier book on the rise of the unelected, I think very much brings out the dangers or the risks of so-called expert agencies, knowledge. But on the other hand, think about the developments in administrative law in the last 50 years, which, Jack, you will be very much familiar. But I would argue that administrative law, sort of below the surface in a sense, below the highlights, administrative law, first of all, has a certain independence from the legislative body. Powers are given by legislation, but once they're given, each of those sites, I would argue, acquires a certain autonomy, a certain independence. And into that, various ingredients operate, all sorts of standards, all sorts of requirements of due process, and not least, engagement of those with an interest. Now, that doesn't mean the population generally. On the other hand, those with an interest are able to engage in that process, monitor the claims made by the body, test it out with conflicting evidence if necessary, and so on. So I think this dangers of expertise have to be moderated by understanding the role of interested parties. That's one point. I would like, that I think brings me to the larger point of, as Jack mentioned, the role of the people in the Constitution. I go back, Frank, to the early chapters in your book where you talk at length about the founding fathers and about the basic assumptions, if you like, of the United States Constitution. I approach them, I have to admit, with a slightly skeptical eye. Remember, James Madison was the one who, in Federalist Paper number 10, very eloquently simply eliminated the people from the political process, except to cast a vote every 4 or 5 years. He says it expressly. We can't trust the people. Indeed, he calls the people a faction, and factions are the major enemy of a modern constitutional order. Factions distort, factions undermine certain interests and groups. Madison is utterly clear in Federalist number 10 that we have to get away from what he called populist democracy. That is, some sense the people engaged in, even controlling the organs of government. We have to abandon that. That was the great fear of American men of property and slaves of the late 18th century. In its place, says Madison, we need representative democracy. Look at the obvious virtues of representative democracy. The object is property. The object of a constitutional order is to protect property. Who are the best protectors of property? Those men of property themselves. And so this was the birth of representative government, representative democracy, that the people had no role other than to vote. The leaders, the men of property, knew what was the common good. Now, of course, I've perhaps overstated that a little, but that's the basic foundation of democracy as we understand it. I was going to ask Frank to take up this theme. Frank, it wasn't clear to me in your book what concept of democracy you had in mind. Was it representative democracy in that Madisonian sense, perhaps with some modifications? Or was there another sense of democracy in the back of your mind?
Well, thank you, Denis. I agree with your analysis of the founding fathers that the role of the people was there. They were to vote, and then they disappear from the scene.
That's right.
And I do make that point in the book. And what I think is important is the change from the Madisonian founding fathers concept of the people, where it was about human nature, where they are reasonable people in one sense, but they're governed by their passions in another. And you need more knowledgeable and informed people to act as their representatives, to John Stuart Mill, where you get away from looking at knowledge on the basis of human nature, and you start talking about systems of knowledge more generally. And then you get to his view of vitality, and people reappear. They're there to debate, particularly with those you don't agree with. They're there to give feedback to governments on the basis of their own experience. And I think they're there to alert governments to new areas of concern. So these are all things which, in my view, people can do. The problem, also flagged for the first time by John Stuart Mill, is that people remain very subject to taking shortcut decisions. They're not, and rely on heuristics, and they are very much likely to be biased. And of course, those heuristics and biases also play into courts and expert bodies, but I think but they should be aware of them. And I think that very often people are not aware. And I think with the growth of the world of the internet and social media, those biases are reinforced because we network with those people who we agree with and who agree with us. And these search algorithms prompt us onto other channels which also reinforce our own biases. So I think that problem of bias and heuristics in public opinion is even worse today than it was 10 years ago, and certainly at the time of John Stuart Mill.
Thank you, Frank. Jack, would you like to comment on that?
You've both used the word elitist. Elitist is just it's like populist. It's become a term of use.
I didn't use that word.
Well, you may have referred to Frank's using it.
Yeah,
the word came out of
Frank used that word. I would dream of
But I mean, if we go to the American, I mean, Frank's book is very focused on the founding fathers and the American and all of that. One reason why I emphasized there are different concepts of separation of powers.
Yeah.
But if you look at the American, in a sense, what happened with the founding fathers, as you say, slave owners, many of them, was that they were replacing one elite across the Atlantic with another elite. And if you then look at all these wonderful safeguards in the Constitution, a Constitution is actually fairly unchangeable, very difficult to change. You see, you can see and you can sense that, and you can look at other examples. You can look at constitutional change that happened in South Korea since its creation. You can see that really what is important is cultural sensitivity and cultural tolerance. And actually, in this country, for all its elitism and for all of that, in the period that I grew up after the Second World War, we had amazingly consensual politics. They called it Butskalism, because you had Rab Butler on the one hand and Gateskill on the other. So I wonder whether the big separation of powers in the US Constitution and the big separation of powers in the French Constitution, whether they're any more resilient than the weak balance that we have in this country.
Interesting, Jack, before I turn to Frank, I've become a great admirer of the Scottish Enlightenment, and particularly David Hume and some of his colleagues.
Adam Smith, you mean?
Sorry?
Adam Smith.
Adam Smith, I particularly mean, but others as well, Ferguson and others. What strikes me about that is David Hume, who I think is one of the great philosophers and for whom these issues were in some ways peripheral to his main philosophy, but he uses the concept of moderation. Now, that may sound a little bit pathetic nowadays, but I think what Hume had in mind is he says two things. Look, on the one hand, constitutions depend entirely on the opinion of the people. Why? Because sheer volume. On the other hand, he says, the real interesting issue is how do you get that opinion to support, acquiesce in was his expression, but basically to support a constitutional order. And the concept he came up with was moderation. It may sound a little bit weak, but if you think about it, you then start to build up what are the elements of moderation. I would pick up Jack's point about the balance of powers as an indicator, as a sign, indeed, of that moderation. I would look at the British Constitution, and actually, I'm a great admirer of the British Constitution because I think it has basically maintained that moderation. It has, in other words, I think, taken enough account of different sectors, different groups, different peoples, different interests, all, if you like, under the general idea of the common good. But with all its drawbacks, I do think that the British institutional structure, legislature, courts, executive, administrative bodies, has, in general, of course, many exceptions, but in general, has found the very balance that Jack has been talking about. And it's importantly not a strict separation of powers. There is certainly a separation of powers in a broad sense, a sort of practical sense. Each institution has a sense of that separation. So, for example, courts. Now, I think you can. 2 years ago, we published a book on the courts and the people, the Putney debates. And I think there are some excellent essays in there which tend to show how the courts have responded in their own way to that sense of moderation that Hume put it. I think our Parliament, in general, some exceptions, you do get the odd lunatic coming along, but in general, with some exceptions, I think our Parliament respects that moderation. The Italian great philosopher of Hume's time, the Italian Giambattista Vico, came up with the idea of equilibrium, remarkably similar. So in order to achieve equilibrium, or balanced in Jack's terms, you need moderation. Frank, what do you think about this?
Well, I agree, but to a large extent. But I think the founding fathers expressed the importance of virtues like accommodation and moderation in different terms. They expressed it in terms of neutrality. In other words, not setting out the aims of policy in the Constitution, but setting out just the institutional framework. And they said specifically, the system had to be ready to correct for mistakes and it couldn't foresee the challenges ahead, and therefore it was neutral as towards the policy objectives. Now that left space for other values which they valued more: accommodation, harmony, tolerance. In other words, those values which enable the setting of democratic politics to take place. Now you, Jack, and Denis, I think, make the further step that the UK system is very good about bringing out these other values. I'm afraid I'm less convinced about the virtues of the British system. I don't think what happened to those poor post office postmasters who demonstrates tolerance or accommodation or moderation. It just represents the regulator and the law going wrong.
So Frank, if I can correct you.
Hang on a minute. It was the fact that it was the employer acting as a prosecutor.
So it went wrong.
Well, so the system went, but the system is putting it right.
This, I think, sorry to interrupt, this is a key point. The system is correcting it. This is the difference. These things come up, but they get corrected. Not all, of course, but I think that's a critical point.
Well, the question is whether it corrects it faster and better than a system where you have a separation of powers, where each branch can claim its own territory and criticize other branches.
Well, we should perhaps we should take an example about legislative power. One of the things we want is for legislation to set up frameworks which will then be administered. And you then have deliberation. You very often have two chambers which balance each other and have different ways. But then we see in many countries a move towards greater executive exercise of power. You sit on a lawn and you make 120 executive orders.
I don't know what country you're thinking of, Jack.
Australia. You sit in this country and you pass skeleton legislation, which leaves somebody sitting anywhere in the country ready to make the rules. So I think the idea that you have a formal separation of powers, but actually, we'll see how long it goes on for. But we haven't heard of one single piece of legislation passed for all the things that are happening at the moment. It's all being done by executive order. And this is within this is within a constitution which I've spent most of my academic life being harangued by American public lawyers, and it's perhaps heard the same, about how we don't really have they have this firm system that guarantees all of this. It really just depends. I like moderate. I don't mind. That balance is one word. It depends on everybody being willing to play. I hate the phrase "play the game," but in a sense, that's what it's about.
I mean, to put it another way, Jack, what behind the constitutional order are social norms, social conventions, social attitudes, and I think that's often left out. Frank, not in Frank's book, he talks about that quite a bit, but I think that's often a dimension that is missing. And this was Hume's point: behind the constitutional order, which after all is an artificial creation, behind it and the working of it depend upon this sense of social understandings, social conventions, rights and wrongs. But anyhow, I want to come, Frank, we're getting short of time. I want to move on to your concept of rights and your concern for rights. Would you like to just outline briefly for our audience, what do you mean when you talk about that rights-based constitutional order?
I essentially mean when rights are expressed in a comprehensive declaration, covering not only legal rights, but also social rights, family rights, and a whole lot of other aspects of social life. when they're used to help to steer policy. And that is rather different from the American concept, the founders, where, as you know, they didn't originally want to include rights at all in the Constitution, but then added a rather limited Bill of Rights. And it's that steering concept which has become very common, including in the I would say in the UK. I think I wave a number of warning flags about. And I think the warnings are that they may be misused as providing mandates to act, being treated as trumps over and above every other consideration or choice. Mill warned that you need to inform values with facts and evidence. I very much agree with that. And I think if you look at the EU, you may see that a regulatory impact assessment and all the attempts to make sure that EU regulatory policy is evidence-based may be overruled by an appeal to rights. I'm also concerned about who animates the system of rights. It's not just cases turning up in front of courts, but it's also a question of lawyers who have an interest in rights, in the special interests who have an interest in rights. It's what Abbott called this linked ecology of interests and linked ecosystems. And this can become very remote from what people think. It becomes very unrepresentative in Jack's terms. And I think that is a problem. And I think there is far too many cases now. One's only got to look at the numbers in front of the ECHR to see really far too greater use of human rights. I was in favor of actually the UK enacting the Human Rights Act and the feature Jack has referred to, but there's far too much referral on. There needs to be tightening up of admissibility criteria or some other way of restraining onward referrals, which help feed this ecosystem of interests. So those are my warnings about rights, that they can be misused, and we need to be much more careful about them.
So just to be clear, Frank, that the danger on your view, if I understand it, is that legislative bodies become hamstrung by all the restrictions of rights. Is that the sort of basic idea, that the legislative process is much more restricted than in, say, the British system, where Parliament is sovereign and more or less subject to some constitutional background, international theories, etc. But is that the problem, that more rights remove power from legislative bodies and therefore affect the democratic process?
Well, that's one criticism, that there's a legalization or judicialization of issues which, according to some, should be handled by legislative bodies. That's one way of looking at it. My concern is goes a bit beyond that, or maybe it's just an interpretation of it, that my concern is that with these linked ecosystems of interests, you get rights adjudication, which is very different from public opinion and representation. And it's the people who are distanced, not as much as the legislatives being put in a tighter box.
Jack, do you want to comment on this?
I mean, I think that there is a real difficult question. The people may elect somebody who stands on a manifesto of removing rights from other people.
Yes, that's right.
And so we know what happened in Europe in the 30s, saw what happened in Southern Africa after 1948. So the question is, I think I'm very sympathetic to what Frank says about too much of this, but there are some things which I think you can't allow a temporary majority to take away without attacking the very humanity-based. I can't describe it in other than in that sort of general way. So I share that. And that's why I put quite a lot of weight and I mainly know about the courts in this country, I put quite a lot of weight on circumspection when people assert their rights by courts saying, well, actually, this is the big margins for them, many different points of view. It's not for us, not for you. And I think that that is what comes back to your balance or your moderation. I think that is the real one. The real problem is, and HS2 is a good example, where we spent millions and millions on protecting the bats. And yet everybody thinks the environment's a good thing. So they're real difficult questions. But I think that for all the critique of the British way of going about things, the way they tried to bring the European Convention on Human Rights into domestic law, while creating effectively a partnership between courts and legislature, has meant that sometimes the legislature has overruled the court, or they've made some change that puts things right, but doesn't just allow the right to trump and stop everything, which is what you're worried about.
Exactly. I agree very much with what you said.
So Frank, if in the light of that, is the United Kingdom different in this respect, say, from our continental neighbours? Leave aside the EU for a moment as a very special constitutional order. You would have compared with, say, France or Germany or Italy, for that matter. Are there significant differences in the way that the balance between the legislative bodies and the courts is achieved, in your view?
Well, there's certainly a difference compared with, say, countries like Belgium, Netherlands, Switzerland, which are definitely more coalition and PR oriented. I would say coalition government is much more common in places like France or Germany. And I think that is a very major difference. Our courts all the courts are referring now on to the ECHR. So the human rights problem is the same everywhere, I think. But I would say the big difference is the tendency to have coalition governments.
So, Frank, just to be clear, you're not arguing against some constitutional or some rights being embedded in constitutional structures, I presume. What your argument, if I understand it, is that we are putting too many rights, in a sense, into that reserve. And the EU is a good example of that. I can certainly see that it's very easy to start embedding more and more rights. What's the best protection against that, in your view?
Well, I think admissibility criteria are important. What do you in fact refer up? And I think referral generally, it would be perfectly possible for the UK courts to say, we're not going to refer this to the ECHR. Self-restraint by courts, of course, is important, as Jack has mentioned, and that also applies to the ECHR.
They don't refer to the ECHR. They used to refer to the ECJ or the CJEU or whatever the acronym is now. But the government doesn't send cases to the...
No, but the courts do.
The courts don't. The courts...
They allow a refer, they allow an appeal.
Well, that's a completely different thing.
No, well, that's what I'm referring to.
Well,
it's the allowance of an appeal, which I regard as which I've described to as a referral. It may not be technically the same, but that's what happens. Cases get referred on. You say it's circumspection. I say it's passing the buck to a higher court.
So your point, just simply put, is that too many of these issues are being put into, in this case, the ECJ, or even within the British courts. Too many of these issues are being resolved as rights issues rather than perhaps legislative decision making.
That's part of it, but it's also that the decisions which come out of rights adjudication can be very different from what the population think are the correct social judgments.
And how do we know about what the population thinks, Rick?
People start saying that's start attacking the rule of law. And and majorities start trying to control the justice system. That's what one sees in the US and in certain countries in Europe. That is in part a reaction to feeling that there are these elitist judges and people on the inside who are wielding power in a way we don't agree with.
Yes, I see that. I think there are a lot of steps in your argument that need to be examined. So you mentioned the majority. On your view of democracy, if the majority is in favor of certain rights being entrenched, then that should be legitimate, shouldn't it?
No, I don't think so.
So what would be the counter-argument?
The elected branch in the US system does work on a majority system, but I say it's important the other branches of government are there to feed their specialized knowledge.
I find it just a bit difficult to get the balance here between the need on the one hand for certain basic rights to be protected, which I think any developed constitutional order recognizes in their different ways, and on the other hand, the putting too many rights in that reserve again comes back to balance. But I wonder let's just be very specific in the British context. What would be an example of a right that, in your view, shouldn't be in that reserve? In other words, is the result of pressure group or elitism or whatever. What would be an example, Frank?
Well, I would say that there are examples of cases for which there's no right answer, should be not referred on or allowed appeal on.
Could you give us an example of
an example where there's no right answer is where parents appeal against a doctor's judgment that there's no cure for their infant's malady and it's better to let them die. These are horrible cases. To my mind, there's no right answer and there's no good way of handling them. And I don't think good is served by allowing them to just go on winding their way up through appeals.
Yeah. And what about second opinions in medicine? Would you allow those? I go to a doctor and he says there's no cure for this. And I said, I'd like a second opinion.
You certainly allow those. You allow them in the kind of case I'm referring to. But when everybody says this is considered professional judgment, then it becomes very difficult.
Well, when everyone says, well, who's everyone?
When all the professionals, your first, second, and third opinion, they all agree that no, there's no treatment. This child has to be allowed to die.
Yes, I agree with you. I just think that sometimes there are influences which contaminate scientific opinion, and on that sort of issue, it is vulnerable to that.
Yes,
you have to ask where the second, third, and fourth opinion are coming from.
Oh no, I totally agree with that, and I would say that the problem is with these sorts of cases is there's no good forum for appeal. Parents obviously have a right to express their view. You could say that judges or juries should also be somehow, or panels should be appointed, but there's no single right answer. But I don't think the answer is to allow the case to go on from a lower court right up to a European court.
If we get away from the very specific issue, Frank, but in general, as a constitutional principle, isn't it a good thing, as something we ought to support, is the protection of certain basic interests, protection against the legislative body and against the administrative executive bodies? Isn't that the nature of historical development of constitutions in Europe, at least? Certain interests become singled out for special protection. They are, after all, interests. We started off with property interests. So much of constitutional history is tied up with protecting property rights. And then, of course, as democracy grew, those rights expanded, and we don't have a Bill of Rights as such, but we have certain very fundamental understandings of rights of due process, for example, a very fundamental right, entirely, well, mainly made by the courts. And yet I don't think anyone, I think it'd be very hard to criticize rights of due process for someone who's thrust into some sort of administrative or judicial process. Anyhow, these are major issues. We could go on. I promised our audience that we would finish at 1 hour's time, and I think that's just about there. But I would like Jack to ask you if there's a final comment or two you'd like to offer on the overall debate, and then I'll ask you the same, Frank.
Well, I think that we've identified discussing these fundamental values raise difficult questions, and people can have different views, and that sometimes it's worth asking more than one person. And I don't think that there is a difference between articulating a difference and suppressing the ability to identify a difference.
Frank, last remark.
Yes, well, when I was asked to write this book, I was a little sort of doubtful about the separation of powers. I don't know, this is the American system. But I became more of a convert, a thinking about it, because I think actually trying to protect your different sources of information in society and your different actors is important, and to have a non-hierarchical relationship between them rather than something like the sovereignty of Parliament is actually an advantage.
Frank, I should just make one remark. It's not the sovereignty of Parliament, it's the sovereignty of the people in Parliament. I know we dropped off the people, but anyhow, on that note, you can see that I'm always watching out for the people. I hear a sort of brief from the people. Well, our hour has expired. Thank you very much, both for your book,
Denis,
and for your comments. We may not have agreed with everything, Frank, but you've certainly created a very stimulated debate, and there's much more to be said. Jack, thank you very much. Again, your academic and judicial background has been enormously important here, beneficial in keeping the debate, I think, on a sort of equitable. I think David Hume would have been proud of you.
Well, I'm a Scot.
Yes. So anyhow, I think Jack has kept us on the straight and narrow, kept us on not the straight and narrow, a balanced intermediate way. Again, in that tradition, I would just end with it, David Hume's moderation. Let's try to find moderation. Thank you very much. Thank you both.
Thank you, Denis.